My name's Ken Carlson. I've been an attorney since 1980, specializing in helping tenants with their landlord problems. I'm a graduate of UC Berkeley and Loyola Law Schools. I operate the caltenantlaw.com website, providing free legal information as well as inexpensive attorney help with tenants' rental problems. For many of you, the idea of suing your landlord is unthinkable and intimidating, like attacking an authority figure, challenging a powerful adversary, or doing something horribly wrong in society. That's how the landlord wants you to think. Snap out of it. The landlord is like the schoolyard bully, full of threats but just as vulnerable as anybody else. If one day all the kids in the schoolyard converged on the bully and beat him up, he would never be a bully again, and neither would anyone else. I'm not advocating violence, but presenting this as a metaphor to say that the landlord's tenants could all take legal action against him at once and financially ruin him. As for the bullies, the bigger they are, the harder they fall. You have to see it from the right perspective. You have a contract with the landlord who has to perform his obligations under the law and the contract just as you do. He thinks it's a one-way street, but it's not. Laws are created to protect you, and you only need to use them. James Madison, who was chosen by our founding fathers to write the U.S. Constitution, said, "The purpose of the law is to prevent the rich from always getting their way." If you can avoid suing, you can get what you want sooner, with less hassle and expense, and even set the pattern for solving other problems in the future. We'll start with that. Behind all litigation is the psychological warfare. It involves the will to fight, the confidence in an ability to win, vulnerability, fears and anxieties, mounting stress, and the need for resolution. The problem landlords are blinded by arrogance, thinking they are above the law and can do and get away with whatever they want without any adverse consequences. They may operate through a corporation or limited liability company, an LLC, that owns another none-of-your-business-who-I-am LLC, hiding behind a fictitious business name that hires a property management company who directs a resident manager to keep you in fear. Mr. Big, as I call him, runs the whole show from his mansion, but he doesn't want you to know who he is or where he is, so the resident manager tells you you don't have the right to know it. The first thing you need to do is find Mr. Big and come to his door at home. You can call the county tax assessor and ask for the name and address of the taxpayer for your address. They give you at least one name and where they send the property tax bill to you over the phone. You can also go to the county recorder's office and get the latest deed and the trust deed, which secures the mortgage loan. These are public documents, not secret. The purpose of recording a deed is to inform all the world who the owner is. If the owner is a corporation, LLC, or limited partnership, the California Secretary of State has a business lookup function online, where you can find the business and download the statement of information for that entity, which shows who the owner is, a place of business, and other information. If the owner is another business entity, you can look them up as well. Your lease may have a fictitious business name like Windsor Arms as your landlord, and your county clerk has a registry where you can look up those names and see who signed for it. The president of the corporation, the managing member of an LLC, and the managing partner of a limited partnership are the Mr. Big you are looking for. Mr. Big is findable in today's internet age. Google his name, check on Facebook, use an online name search or phone directory. Keep in mind that there are others with similar names, so a middle name or initial, approximate age, and so forth will help narrow down the search. You may even find pictures of him, which you should save. If you have a friend in real estate, they have database connections to look up the property and see who it is that owns it. There is a special tax code for a personal residence because it is taxed differently than for a business or income property. The county tax assessor may also be able to provide you with that information as well. You can always hire a private investigator to do all this for you if you wish. You go to Mr. Big's home on a weekend and ring the bell. The problem may not start with Mr. Big, but he can do something about it. He hires people who hire people who hire people. The problem may be in that chain of command, like the property management company or the resident manager. Mr. Big can resolve it, like firing the property management company to get someone who doesn't get him sued. It is important to contact Mr. Big himself, because unless the top guy knows what's going on, your ability to collect from him or his company is cut off because he says he didn't know. You tell Mr. Big that you are one of the tenants at your address, and you have this problem. Keep it simple at first, and he can ask questions if he wants more details. You explain that while your attorney is urging you to sue him and his company for what's going on, you want to give him the benefit of the doubt to see if he will fix this and act fairly. While you are talking with him, you can take his picture, whether he agrees or not. Take a picture of his house from across the street so it's easily identifiable, and as well as his car with the plate number. He's not going to make a decision right then based on your word, but he will have to look into it and confirm what you said. You can give him your name, phone, email, and address and ask him to check into it and contact you back personally. He either does or he doesn't. What does all this have to do with psychological warfare? Plenty. First, you confronted Mr. Big adult to adult, eye level, not as a medieval serf to his majesty, but as an equal in the eyes of the law. You also are requiring him to do something, not the other way around, under threat of being sued. You had the guts to face him directly, marching into the lion's den, so you're not afraid of him, but like pulling the curtain away and exposing Oz. You had the intelligence and commitment to find him, despite all of his insulating none-of-your-business layers, which makes your threat of suing him real. You have taken the proper steps to make him and his company liable to you, so he can't claim that he didn't know. It shows that you know what you're doing and how. You know where he is. You know where he lives, giving him the dreaded sense of vulnerability that you, another tenant, or someone on your behalf may come to personally injure him, damage his home or property, and worse. I'm not advocating that, of course, but you can't stop him from worrying about that possibility. You certainly don't want to suggest anything like that when talking to him, particularly because if something does happen, he would tell the police that you threatened it. However, you can mention that the other tenants in the building also have concerns that are not being met, so you want to share his contact information with them so that they can get past the managers he's relied on. You explain that with the tenant's direct feedback, he can have free quality control by which he can order the property managers to take care of the problem if they're unresponsive to the tenant's requests. Explaining it as quality control presumes his concern that things are done correctly. However, as a practical matter, he doesn't really want tenants contacting him directly. That's why he hired a property management company. It becomes best for him at that point to order his property management company to respond positively to the tenant's complaints and instruct the resident manager accordingly. You want to follow through with sharing his contact information with the other tenants. A single page that says it all can be handed to all of the other tenants in the building, or posted on the bulletin board, or mailed to each using the names and unit numbers on the mailboxes. It says if management won't handle the problem, contact Mr. Big directly, who would appreciate their feedback on the quality of management of his property. Give his name, address, phone, Facebook and social media, a photo of Mr. Big, a photo of his house and car, and a Google map and description of how to get to his house from here. You can also share the business connection that Mr. Big is the president of the corporation that owns the LLC, DBA Windsor Arms, that owns the property, which is managed by X company who hires the resident manager. One of the tenants will surely give this to the resident manager, who will contact the management company, who will call Mr. Big. He will see that you weren't kidding, and this could get out of hand. Yes, it could. If the problem is not Mr. Big, he can take care of the problem with a few phone calls. The property management company will be resentful because not only did you go over their heads, but you put their contract with Mr. Big in jeopardy. The egos of the little people with power who work there will be bruised, as will the resident manager's ego. Well, if they won't do their job and respect you, at least they can fear you. If you're unhappy, you sue Mr. Big, who fires them as part of the settlement. Now they're the vulnerable one, and the bullying stops. You won the psychological war. The other tenants may also enjoy the benefits of your good work. You got what you wanted without suing. All is right with the world. If the problem is Mr. Big, the game is on, and you're already ahead of the game in the psychological warfare. It might begin with a hostile reaction when you visit Mr. Big, whose fear of your finding him hits the fight or flight button. How dare you come to my house and threaten me? Weak people use arrogance to protect their fragile ego. You remain calm despite his hostility, because calmness shows your strength and scares him all the more. You explain that you were just trying to solve the problem without suing him and save him a lot of money by getting his people to do the right thing. Tell him that when things don't turn out as he hopes, and he's whining that you were picking on him, he should remember this day when you offered to settle everything and he said, "What? No." Say nothing more and go home. If you get the negative response, the flyer with Mr. Big's information on it should explain that he was hostile to your request, and if they care about how they are treated, we should all stick together. You give your name, unit number, and email address, and ask them to email you back with theirs. It's the beginning of a tenant association within the building. That gives you added protection as a legal defense against a retaliatory eviction and other harassment by the management. You can prepare small claims complaints, filled out with the names and addresses of Mr. Big, the corporate or LLC owners, the management company, and the resident manager, as well as the address of the court. You put on the tenant's street address and leave open their name and unit number, and then send it out to each of them in case they want to sue the landlord as well. They have Mr. Big's address in the flyer and how to get there to serve him with the lawsuit. You can provide the name and address of the agent for service of process of the business entities as well. That will get back to Mr. Big too and amplify his nervousness and vulnerability. Pulling your case together. You need evidence. Pictures are the easiest to put together. Ideally, you want one good picture of each problem, so you can take 10, but pick the best. Video should only be used when movement needs to be shown, like a leak or wind or a loose railing. You want pictures not only of the defect, but of its place in the affected area. If it is the electric outlet next to your bed that's not working, you have a picture of your bedroom showing the bed and outlet, and then a close-up of the outlet itself. If the problem is outside, you have the pictures showing the situation, such as your apartment being adjacent to the noisy neighbor. A hole needs size comparison, like a hand pointing to it. A window or door gap needs a paper sticking through it. A floor leak needs a spread-out newspaper page showing the darker area that is wet. A photo of rat or cockroach droppings or a chewed package can make that point. A piece of toilet tissue dangling in front of a window or door cap can show the wind blowing through. Hardware stores have mold testing kits where you can mail a scraped sample to a lab for an official printed lab report. You also need written evidence. The rental agreement, emails, texts, notices, letters, reports, whatever you have to show the situation. You put them in chronological order, separating the emails and texts from each other so that the strings in a conversation are broken down into the individual statement, like Exhibit 1, how are you? Exhibit 2, fine. You will be using these to make the timeline of what happened, and then what happened, so you have an orderly presentation for the judge. If the problem concerns structural defects, and the local building department code enforcement inspectors might cite it, you need to call them in. Not only will they force the landlord to fix it, but their citation and other communications will help you prove that the condition really existed and that it was as bad as you said. The county health department has one section that concerns mold, rats, cockroaches, and other living things, using the term vector, like vector control. Another health department section deals with other things like sewage spills, asbestos, and other unsafe or unhealthy conditions, with a name like environmental services. If there is a fire hazard, the local fire department non-emergency line will get you the fire marshal, who will come out right away to check and cite the defect. If the problem concerns gas, such as a leak or non-working stove or room furnace, the supplier, like Southern California Gas Company, will come out immediately to check and tag the defect. For gas-related things, the building department inspectors go by what the gas company says. There is no charge to you for any of those inspections. You want to get the business cards of the inspector and arrange to get a copy of their report when it's finished, so you have that as evidence. If you have a problem getting the government inspectors to come out or to cite the landlord for obvious violations, you go to the next city council meeting or county board of supervisors meeting and complain to them about it at the oral communication time of the meeting. That will get action. It may be that the landlord knew or should have known about the problem, but he didn't tell you when you were signing the agreement because, well, he wanted to get top dollar rent and trick you into signing the lease for an extended time and move into his place instead of someplace else. The advertisement to which you responded and any early communications between you and the landlord would also be evidence to include. You pull together the timeline from all of this and keep updating the timeline as the landlord takes action or doesn't. And you keep the conversations together. Whether you handle the lawsuit by yourself or with the help of an attorney, you are the one who needs to gather this information. In one last effort to avoid the expense and hassle of the lawsuit, you can write to Mr. Big, telling him all that you have done in preparation for what you are about to do, describing your communication at his house and what he said, asking that he take care of the problems you include. This letter is more for the judge to read, making it clear that you tried to avoid suing and that the landlord was hostile, that you have all this information, and that Mr. Big can't claim that he didn't know. Then you're ready to sue. The court system is divided into levels. The bottom level is small claims court, where you can sue the landlord for up to $12,500 twice per calendar year. It looks like People's Court or Judge Judy on TV. The advantages are that the filing fee is only $30 to $75, lawyers are not allowed at trial, there are no technical evidence rules, and it's held within a couple of months. The disadvantages are that the trial is very short, and the landlord could surprise you with a big lie at trial to win. There is no appeal by you, but the landlord can appeal it. That appeal is usually a brand new trial with a different judge, evidence rules, and lawyers. The middle level is the limited division of the Superior Court. It handles cases up to $35,000. You definitely need a lawyer to help you prepare the case, even if you officially represent yourself, because of all the technical requirements. One advantage is discovery. Discovery means that you can make the landlord provide documents, answer questions, and admit things in writing, and take depositions, so you're not surprised at trial. Another advantage is having a jury trial, adding the risk and expense for the landlord in defending. You can take your time at trial presenting your case. The judges are generally better than the ones handling small claims cases. You can get temporary injunctions. The disadvantages are that it can cost thousands of dollars and take 2 years or more to come to trial. If the landlord's insurance company steps in, their primary tactic is to make it so complicated and expensive that you give up. The insurance company might settle sooner if the price is right. The top level of the court is the unlimited division of the Superior Court, if you're suing for more than $35,000 or a permanent injunction. The same advantages and disadvantages as in the limited division otherwise apply. You, as the plaintiff, would file one lawsuit against all defendants. In most cases, the person who does these things to you is the resident manager or management company. But the one primarily responsible is the owner, called the principal, on whose behalf they act. You sue all the owners, each level of the ownership and management, and then find out during discovery who did what. You file a complaint in the court and then properly serve a copy of it and the summons, if applicable, to each defendant. You don't have to continue living there to sue. You can move out and sue from your new location, or stay where you are and sue, if you choose. The term used for the money you're seeking is called damages. There are 5 different types. The first type is called special damages, which are out-of-pocket expenses like the replacement cost of something the manager stole. Second is called general damages for intangible things like the hassle and stress of a retaliatory eviction. Third is statutory damages, a special penalty under the particular law the landlord violated, such as the bad faith penalty for not returning your security deposit. Fourth is punitive damages, also called exemplary damages, which is an extra punishment where what he did was with fraud, oppression, or malice. That amount is determined in part by how wealthy the landlord is. That's the bigger they are, harder they fall part I mentioned earlier. Fifth is restitution, which is to give back money or things to you, such as if you rented an illegal unit, you're entitled to get all of your money back. Now, the reasons for which you are suing are called causes of action. There are many different types that you can sue the landlord for. A cause of action describes what rights you have, what the landlord did wrong, why the landlord is liable to you for what he did, and the way in which you were harmed, including the dollar amount of damages. One act or situation can raise several causes of action. For example, a cockroach infestation could be a breach of contract, nuisance, and the basis of fraud, because the landlord didn't tell you about it when he rented you the place. I want to introduce you to each of these causes of action now, so that you could see which of them are like your situation. Many of you are so accustomed to landlord abuse that these kinds of things seem normal to you, and you didn't know that you could sue for them. Please also recognize that there are even more things that you can sue for than I am covering here, either because they are too hard to explain or they are too rare an occurrence. When you talk to the lawyer, be sure to mention things that are not in the list, just in case it's something that you can also sue for. A breach of contract is where you have a contract like an oral or written rental agreement, and the landlord does not do what the contract itself or the law concerning that contract requires, which caused you some loss or disadvantage. Breach means breaking the contract by doing or not doing something contrary to the terms of the contract. The term covenant just means a part of the contract. A contract is a collection of covenants. There are 4 different types of breach of contract in landlord-tenant law. First is the breach of the terms of the agreement itself. For example, the agreement says you have a parking space, but then the landlord gives it to someone else. It could also be a violation of the law, like charging an illegal rent, late fees, or an excessive security deposit. The second type of breach is the implied warranty of habitability. By law, it is the landlord's duty to first provide a habitable dwelling before he can even ask for rent. For example, if you have a cockroach infestation, it is a breach of contract, and you are entitled to sue for a reduced rent, compensation for past rent, and some money for having to endure it all. Habitability includes things that are also a nuisance. The third type of breach is the implied covenant of good faith and fair dealing, which is imposed by law in every rental agreement. For example, if you have a rent-controlled apartment where the rent control law allows you to have an additional occupant, like a girlfriend, and the landlord refuses to permit that because, he wants you to leave so he can jack up the rent, that would be a bad faith breach and a breach of this covenant. The fourth type is quiet enjoyment. You have the right to not have anyone disturbing your peace and quiet or trying to evict you. For example, if you have noisy neighbors whom the resident manager will not make quiet down or evict, it breaches this covenant. Also, the landlord who is about to lose the property by foreclosure but doesn't tell you that when he's renting to you breaches this covenant because the foreclosure buyer will then try to evict you. The landlord trying to evict you is also a breach of this covenant. Civil Code 1942.5 and case law protect you from retaliation by the landlord for exercising any rights under law, including complaining about defects, calling the building department, calling the police, or forming a tenant association in your building. It prohibits as retaliation raising rent, decreasing services, threatening eviction, or evicting you, or harassing you. You can sue for general and special damages, statutory damages, and punitive damages. You're also entitled to attorney's fees under this statute. You can sue the landlord and his lawyer for filing and prosecuting an eviction case which you won that had no valid basis and was filed maliciously, such as to punish you for complaining about a lack of heat. You can get general and special damages, as well as punitive damages. We had a case where the jury awarded our client $1 million for that. The protections against sexual harassment apply in the landlord-tenant context. So a resident manager who expects sex from a tenant to avoid getting evicted would cause the owner to be liable for general damages, possibly special damages such as hospital bills, and punitive damages. Sexual harassment includes non-sexual behavior directed to someone as hostility or other circumstances. Fraud is where the landlord lies to you about something in order to, say, get you to sign the lease. Deceit is a type of fraud, such as where the landlord is obligated to tell you about negative things that could affect your decision to pay top dollar for this place, but conceals that information in order to trick you into signing. You are probably entitled to restitution of all the money you've paid as rent and deposit, to general and special damages having endured these conditions, and punitive damages for lying. Constructive eviction means that you were driven out of possession by the unpleasantness or danger of the situation. You must have moved out in order to sue for this, but you simply show the conditions and why you had to move to minimize your suffering from staying there. You can collect moving costs, the higher rent portion that you have to pay for a comparable place, the value of the rest of your lease, and other things, such as special and general damages. Punitive damages may also apply here. Rescission means to cancel the lease, which can be based on fraud or deceit in tricking you to sign the lease, or because the lease itself is illegal. For example, the landlord has a garage that he has illegally converted to an apartment, which he is renting to you, or you live in the house with that converted garage. There are other situations where the right to rescission applies. You are entitled to restitution of all the money you paid, general and special damages and punitive damages, and you move out. The landlord who wants to evict you has to go through the legal process of unlawful detainer. He cannot simply change the locks, throw your stuff out, turn off utilities, remove doors and windows, or otherwise have you removed, such as by police on false charges. That violates Civil Code Section 789.3, where you get actual, special, and general damages, statutory damages of $100 per day that it continues, punitive damages, and attorney's fees. A nuisance is anything that is hazardous to health, offensive to the senses, or that blocks coming and going. Examples are mold, mice, cockroaches, nasty smells, loud noises, exposed carpet tacking strips, and blocking your car's entrance or leaving. It entitles you to general damages, maybe special damages, and possibly punitive damages if fraud, oppression, or malice are involved. You own the exclusive right to possession. That's what renting is. The landlord may own the title to the property, but not the right to possession while you live there until you permanently leave. Civil Code 1954 limits the ability of the landlord to come in, which is emergencies like a fire, or by your consent, or upon proper written notice to make repairs, show the property, or do a preliminary inspection before you move out. No other reason, like general inspections, is permitted, even though it's on the landlord's form notice to look official. Most importantly, the landlord cannot abuse the right to enter, such as by having an open house, or doing major construction, or staying after business hours to complete a repair. you say, "Get out." If they don't, you call the police and have them removed. Get their names and then sue them all for trespass. You get at least general damages and probably punitive damages. This comes in one of two forms usually. First is the landlord, manager, or workman enters your home, but then takes pictures of your living conditions or goes through your closets or drawers. Under Section 1954 activities, their access is limited to those. Anything else is an invasion of privacy. The other common violation is the resident manager telling other tenants about your finances, pending eviction, or personal matters. The landlord may have rights to know certain things, but not to share them with strangers like your neighbors. If you can prove it, you can get at least general and punitive damages. This is the general term for slander or libel, where the landlord or resident manager tells other people false things about you, such as posting a scandalous but fake reason for eviction in a notice stuck on your door for the neighbors to read. You are entitled to general and punitive damages for that. This is the legal term for illegal touching, which can be violent hitting, shoving you aside while the manager barges into your home, or touching your body anywhere. It may also be a criminal offense that the police handle, but even if the police take no action, you can still sue the landlord for general and punitive damages and special damages such as hospital expenses. This actually requires really shocking misbehavior that results in some measurable harm to you, not just hassling you over petty things as many resident managers do. For example, a landlord pursued a bogus eviction to the point where the tenant wife suffered a miscarriage from the stress. How bad it is depends on the jury, but you can include it in your lawsuit in case the jury agrees with you, awards general and perhaps special and punitive damages in your favor. Conversion is the civil equivalent of stealing. The manager who enters your apartment and steals jewelry or figurines while you're away at work is a burglar committing a felony and is converting your personal property. The landlord is liable for that. If you're evicted, you're entitled to remove and recover all of your personal property remaining in the place, which the landlord must safely store and protect, either in place or move to a storage facility. The landlord who thinks that you have forfeited your rights to these things after eviction and throws them in a dumpster or steals them or moves them to a vacant lot for the public to pick through is converting your property. You get special, general, and punitive damages for this. One tenant whose property was valued at $10,000 was awarded a judgment of $25,000 because the conduct of the landlord was so outrageous. Civil Code 1950.5 requires the landlord to refund your deposit within 21 days after you leave, minus legal deductions, with a proper accounting including receipts for money spent. See the security deposit video for the details on this. The bad faith retention penalty is statutory damages equal to twice the amount of the deposit, in addition to restitution of the remainder of your deposit, and possibly punitive damages. In the eviction process, landlords get away with murder as clerks screw things up, judges let the landlord win despite knowing it's wrong. The law is just being abandoned for political reasons, to help the rich always get their way. You can lose the eviction case, however, and still sue for wrongful eviction for any number of reasons. It may be for not being served with eviction papers at all, or the faulty basis of the eviction, such as retaliation, or for withholding rent on an uninhabitable place. Depending on the circumstances, you can get special and general damages as well as punitive damages. There are so many: rent control, just cause eviction, Protecting Tenants at Foreclosure Act, Tenant Protection Act, Tenant Relief Act, Anti-Harassment Ordinances, Tenant Relocation Laws, COVID protections, and others. Each provide rights designed to help you. When the landlord disregards those laws, you can sue the landlord for the violations of those laws, which may include statutory damages as well as general and special damages you suffered, and probably involve punitive damages as well. Quantum meruit is Latin. It means how much it's worth. It applies where a landlord asks a tenant to do something for him, but there is no agreed price. It could be doing gardening, making repairs of the property, making improvements, or collecting rents from other tenants. The law says that you are entitled to the reasonable value, that is, quantum meruit, of the work that you do, not just the cost of materials. General and special damages would apply, and possibly punitive damage for the fraud and malice likely to be involved. Slander of credit happens when the landlord gets an eviction judgment against the person which was not properly obtained, as by a wrongful eviction. It most commonly occurs when the landlord files an eviction case against not only the tenant, but names as defendants others who were not on the lease. It could be a former roommate who is long gone, or the boyfriend, girlfriend, friend, child, or relative of that tenant whose name the landlord knows. They are falsely accused of breaking the contract to which they were not a party. That is slander and libel. It also occurs when the actual tenant is falsely evicted. Blacklisting companies such as UD Registry write down the names of defendants in eviction cases where there is a judgment, and then sell that information to landlords who are doing background checks of prospective tenants. A blacklisted tenant's application is thereby rejected. She has a great difficulty finding a new place because she is on that blacklist. If the judgment includes a money award, it affects the normal credit agencies, lowering the credit score and preventing that falsely named defendant from buying a car, getting a loan, buying a house, and other things. Slander of credit has long and severe consequences, so that general, special, and punitive damages should apply against the landlord who told his lawyer to add the names of these people just to be extra mean. Of course, tenants who have been injured by conditions in the premises are entitled to sue for their personal injury as a form of negligence. This includes special damages to cover medical expenses and lost work, and general damages for pain and suffering resulting from that event. It may be a claim that the regular personal injury attorneys are not interested in because there isn't enough money involved or other reasons. No matter, you can still include it in your lawsuit. Resident managers have no life, being stuck in their apartment, handling multiple problems with vague duties. Ironically, they may be ripped off more than all the other tenants. California's minimum wage laws, including the annually updated IWC Order 5-2001, is written for the public housekeeping industry, which includes resident managers. Resident managers are required to be paid at least bi-weekly for every hour they are required or permitted to work at the applicable minimum wage rate. They rarely are, although entitled to huge amounts of back pay and waiting time penalties. If there is a written rental agreement, the value of their apartment may be deducted from the minimum wage up to $938 or $1,379 for 2025 for a single or couple, respectively, hired to manage. If there is no written agreement, they get the place for free and no deduction from their minimum wage is allowed. Managers typically have only an oral agreement and only get a rent reduction or a minor payment to pay for groceries. The landlord has the obligation to keep track of the manager's hours working, but they never do. So, the manager's estimate of the hours they worked becomes the official basis for the award. The wages are general damages and statutory damages, such as waiting time penalties, are imposed as well. Managers who have been working for a few years might learn that they're entitled to over $100,000 in back pay, and if they rent, a refund of all that rent. For tenants who are at least 65 years of age or are dependent adults, grounds for elder abuse may be available over a broad range of abuses, from fraudulently taking away real or personal property to depriving the person of adequate heat or causing isolation by denying co-occupancy by a caregiver. This law is relatively new and expanding. When in doubt, include it in your complaint. Tenants have asked, what good is a judgment against the landlord? He's not going to want to pay it. That's where a levy and judgment debtor exam come in. A levy is how you have the sheriff collect your money judgment. One of the best ways is to have the sheriff collect rent from all the other tenants. They learn that you hit the jackpot, and they could too. You could have the sheriff attach the bank account where the rent is deposited, or even have the sheriff put the apartment building up for auction. You can also require the landlord to come into court for a judgment debtor exam, known as a order to appear, or ORAP for short. You can ask him where his assets are and have the judge order him to turn over his car, his boat, his gold, or whatever to you. It's a humiliating experience for the landlord to be shaken down by one of his tenants in front of the judge, but it provides the incentive to just write the damn check to you and have it over with. Insurance companies may provide the landlord a free lawyer and pay the judgment for negligence or contract disputes, but they cannot insure intentional misconduct like fraud and battery and retaliation. Insurance company lawyers start settling at very low amounts in the beginning, but offer policy limits just before trial begins. Throughout the lawsuit, the landlord's lawyers and even the judge may try to talk you out of it, telling you that you don't have a case and to settle for a paltry sum. Don't fall for it. In that $1 million judgment case I told you about, the landlord offered only $5,000 to settle the case just before the trial started. Of course, it is possible that you spend a lot of money fighting the case and still lose, or have to pay the landlord's legal fees. The landlord could also file a countersuit for some claim and try to neutralize your claim. However, the dilemma faced by the landlord is that if you lose, you may not be collectible, or you file bankruptcy, and there's no winning for the landlord. Paying you is the only way for the landlord to cut his own losses. Whatever you get is probably better than you have now. Think about it. You could continue suffering the abuse or move away. Maybe you can't handle stress and confrontation or can't afford to sue. But you watched this video all the way through, so part of you sees what you can do about it. You don't want to wish that you had and hate yourself for not trying. If you would like more information about this before you decide, just set up a consultation with one of our lawyers to make the final choice with confidence. It's your life. We're just here to help.